Hey everyone, this is Cooper Knowlton. I am joined with the newest member of BFKP, Bradley Pollina, to do a little bit of a BFKP explainer. Got to get that P in there. And today we are going to be chatting with Brad about mechanics liens. It's a question that we get a lot of questions about, or an issue that we get a lot of questions about. And so going to just spend a few minutes just chatting through kind of the basics, what you need to know, if you're, a contractor, an architect, or also a homeowner who's potentially maybe in a situation where you are in a dispute with one of these individuals, and maybe there's a threat of a mechanics lien looming. So important topic. Maybe we could just start off, Brad, by jumping in and just kind of giving like a broad strokes, like what is a mechanics lien?
Sure. And I should say it's relevant not only if you're a contractor, a supplier, a homeowner, but also this comes up a lot when we're representing owners and developers, right? Because they are overseeing construction projects that have all sorts of different people working on them, all sorts of different contractors and suppliers, any number of whom can file liens. So what is a lien? A mechanics lien is a security interest in a piece of real estate that arises out of what's called a permanent improvement to the real property. As I mentioned, most contractors, material suppliers, and certain design professionals have a legal right to file a mechanics lien on the real estate in question, the real property in question, if they are not paid in full for their work. And the lien is actually a form, a notice of mechanics lien that you file in the county clerk's office where the actual property is located.
So what are the requirements? Can anyone just go and fill out this form, or are there specific requirements that must be met in order to start the mechanics lien process?
Sure. So I think the first thing to note is that it's a very powerful tool. There are a number of reasons it's very powerful, but in response to your question, the first thing that's kind of surprising to a lot of people is that you can file a lien. You can use an attorney. You can go to their lien services that charge a flat fee to do this. You can basically do it on your own. You don't need to go to court to get a judge's permission. You don't need to apply to any agency. You essentially prepare and file and sign the lien on your own based on information that you, as what's called the lienor, the lien holder, information that the lienor supplies for inclusion in the lien. It's very powerful for that primary reason, that you are empowered to just do it without seeking anyone's permission. And relatedly, once a lien is filed on a piece of property, it's actually very hard to get rid of. We'll kind of go into that in a minute. How do you challenge them? Are there ways to remove them? Are there ways to discharge them in court? And there are sort of intricate answers to that, but they're more or less kind of hard to once you're faced with a lien, it can be a bit of a hassle if you're the homeowner or property owner. I think the other thing that you're asking about, how do you start the process, is the key deadline to be aware of. If we're talking about primarily right now, private liens on commercial projects, a lien has to be filed within 8 months of the end of the project, or the last time that you supplied labor or materials on the project.
Gotcha. So if you go down to the county clerk's office, you fill out this paperwork, you then have the lien. What does that mean at that point? How are liens subsequently enforced, or are there further things that I need to do in order to have this lien matter or mean anything or have any real teeth?
So there are a few different answers to that. I mean, first of all, once you file a lien, assuming, I said there are somewhat intricate processes and deadlines and procedures that you should be aware of, but assuming you comply with all of those, which are not terribly complicated, you now have a security interest in that property. So for example, if the property is sold tomorrow, you've got an unpaid security interest that's going to need to be satisfied in connection with that sale. Also, just by filing the lien, from a practical perspective, you as the party filing the lien, or your attorney that helped you file the lien, you may very well get a phone call pretty quickly from somebody on the other side, whether it's a contractor that's upstream on the construction project or the property owner. They may say, hey, you filed this lien. I'm not particularly happy about it. What do you want? You filed a lien for $100,000. I think the amount's wrong, or can I pay you 80 and make it go away? So the first thing to keep in mind is that the sheer filing of the lien may be enough to be the catalyst for a conversation with the property owner or the upstream contractor. Really, though, if assuming nothing, sort of money doesn't start to fall out of the sky once the lien is filed, then yes, you can formally and you must formally enforce a lien in court through a foreclosure action. Mechanics liens as encumbrances, security interests on property, are enforced in a very similar way to mortgages and how a bank would actually file a foreclosure action to enforce its unpaid mortgage.
And if you don't, there's also a statutory timeline that has to be followed for that too, right? Like if you file the lien and then you don't do anything about it for a number of years, can you then come back years later and collect on it? Or do you have to then like take the next steps within a certain period of time?
Well, so in its simplest form, the deadline to enforce your lien is 1 year. Now you can extend a lien for another year, again, without getting anyone's permission, without a court order. Your attorney or whoever helped you file the lien goes down to the county clerk's office and files another form, an extension of mechanics lien. As long as that's done before the year is out, you've now got another year scot-free. It can actually be extended another year, but now you've got to go to court. It's not a particularly difficult application to get a judge to sign off on, but you can essentially have a lien. You can keep a lien alive for a few years. So what you sometimes see, especially with smaller liens, you may have a party that has a $10, $20, $50,000 lien. Litigation is very expensive. They may try to file a lien and kind of hang back and see if somebody pops up and wants to pay the lien and actually not take the step of going to court to foreclose it. And what actually may happen is another person with a mechanics lien on the same property, if they go to court, if they have a bigger lien, let's say I've got a tiny little $10,000 lien, but somebody's got $1 million lien, I may hedge my bets and try to save some money, wait for the party with the $1 million lien to go to court and foreclose it. All the other people that have security interests in the property are going to get swept up in that case. And something I haven't mentioned, but is sort of important to note, is that a foreclosure action, actually, if you litigate it all the way through, it results in a sale of the property. That's very rarely the case. It's very uncommon to actually have the litigation all the way through to a sale, because generally, if I own a piece of property and if I got 5 liens on it or however many liens on it, I'm probably just going to step up and be incentivized to pay people off to get rid of their liens, right, rather than lose a valuable piece of real estate in a foreclosure sale.
So I think you sort of loosely touched on it, but maybe you can sort of more directly address the question of, if you are a homeowner or business owner and you do have a lien filed and you obviously you mentioned that you can call up the person who filed the lien and negotiate a resolution. But let's say you think that the work they did, they don't deserve to be paid because the work they did was terrible, or that's
literally every case.
Of course, exactly.
That is filed, there is somebody that thinks that the lien is invalid or it's overstated, it's excessive, whatever it is. So,
right. So what do you do? What do you do if you're in that situation? How do you begin challenging? How do you begin fighting back and getting this lien hopefully removed without having to just pay up?
Right. So, of course, just not to lose the forest for the trees, you can always try to settle with the person that has the lien. And by the way, something that is not always clear to everyone is the lien is just one legal avenue, one legal tool to try to secure payment. Even if you don't have a lien and you supplied lumber that went into a house, you can still sue the contractor, the owner, for failure to pay under your contract. Right. So the lien, it's not as if your entitlement to pay rises and falls with the lien. It's just that the lien is a particularly powerful tool because it grants you an actual security interest in the property that is kind of hard to make go away. So if you're a property owner, whether you're a homeowner or a commercial property owner, developer, and you have liens that are getting slapped in the building, what do you do? Assuming you don't want to pay or you haven't been able to negotiate a resolution, It sort of depends on the circumstances. Let's take a commercial project, for example, that might be millions of dollars, tens of millions of dollars in development related costs. Your first priority is to keep that project moving. Maybe you have a construction loan. Your lender does not like the fact that people are putting other security interests on the property that are going to somehow threaten the lender's interest in the property. A common tool that's available that doesn't invalidate the lien, but removes the lien from title to the property is what's called bonding the lien or securing a lien discharge bond. So very briefly and kind of oversimplified, what happens there is, let's say you have a $100,000 lien. The lien law says I can go out as the property owner to a bond surety company. It's usually an arm of an insurance company. And if I procure a bond in 110% of the amount of the lien is not eliminated. The unpaid party can still pursue payment,
Right.
but the lien's actually removed and no longer clouds title to the property. It's no longer an encumbrance on the property. You still have a lien foreclosure action. You still might wind up in court. But if I'm a developer and my lender's breathing down my neck to get rid of the lien, I need to keep the project moving. This is sort of just a short-term fix to remove the lien from the actual real property itself, right? Gotcha. Like I said, I still might have to fight it out later in court with the supplier or the subcontractor or the general contractor. It's not as if bonding the lien, gets rid of the payment dispute, right?
And at that point, it's really just you are litigating a dispute just like any other dispute that you would litigate through the court system, and all those problems that you're arguing about, or that we alluded to before, whether how much should have been paid, the quality of the work, all those things. Then you're really just in a classic civil litigation case.
Classic civil litigation. Was the work up to par under the contract? Does the owner or the general contractor that's fighting the lien have any legitimate reasons to withhold payments from the lien? Or that's exactly right. While we're on this topic, there's kind of an overarching principle that's a little frustrating to people. It's a feature of New York law. With very narrow exceptions, if you want to challenge a lien, you really can only do so in the context of a full-blown lien foreclosure action. And I think something you alluded to a minute ago was the lien's overblown, the amount is invalid. This contractor says I owe them $800,000. I only owe them $200,000, or I don't owe them anything.
Right.
That's probably the most common phone call you get as a construction attorney. Somebody says, I've got a lien on my building. It's nonsensical. I don't owe this party a dime. There is really no direct cheap route to the courthouse to kind of go in front of a judge and say, Judge, this lien is overblown by a factor of 100 and it should be removed. You need to actually litigate that in the context of a full-blown lien foreclosure action. I said a minute ago, there are narrow exceptions that do allow you to kind of directly attack a lien. There's a process in New York law that you should be aware of called a petition for summary discharge. And a lot of people try this. It doesn't work because courts know you can really only challenge a lien in a full-blown foreclosure action. But what you might try to do is go to a judge, file a summary discharge petition based on what's called a facial defect in the lien. Mm-hmm. And to give you the clearest example of that is when you file a lien, there are, 8 or 10 data points you need to include: the name of the lienor, the date the work was last provided, and the general nature of the work or materials provided. So a classic example of a facial defect in a lien would be in this one line in the lien when you describe the materials provided or the type of work provided. If you describe something that's not considered lienable work, I think I mentioned at the beginning of our chat, you need to have provided a permanent improvement. Oftentimes that's really not terribly complicated. If you installed a plumbing system or an HVAC system, or you provided lumber that was used in the frame of a house, it's pretty much beyond dispute. Those are all permanent improvements. But what if you were a company that provided hand soap to be used in the bathroom on a construction site? I mean, and you literally see these cases come up. if your lien describes something that is clearly not a permanent improvement,
Right.
then you as the property owner, you sort of hit the jackpot because you can go right into court in a very streamlined and generally very cost-effective way and go in front of a judge and say, Judge, this isn't lienable work and the lien should be discharged.
Right. And like everything, a lot of times you see these contracts that the lien is attempting to enforce is like there's permanent improvements, but then there's other things there's maintenance components too,
Yep.
right? There's components that are not, and then it gets really complicated, obviously, because there are some permanent improvements involved in that $200,000, but there are also things that are not. And then, that's what's
yeah, it could be it could be a mixed bag, and that's somewhat
totally.
people that do this work a lot and have filed hundreds of liens. It's a little bit of an art form.
Totally.
It's a notarized document. It has to be true. But if there are doubts around the margins, yes, what you just suggested, people might say, well, I supplied $5,000 worth of hand soap, but I did $195,000 worth of, supplying lumber. So I'm just going to file a $200,000 lien and let the owner fight with me in court later. You see that happen a fair bit.
Right. So I guess kind of the last question is, we've talked about kind of what a really like powerful tool this can be for certain professionals. Are there any though, pitfalls that again, a contractor, home improvement professional is thinking about doing this? Kind of everything you've described filing a lien sounds way easier than filing starting a lawsuit in civil court, even though there are many similarities and it may ultimately kind of result in the same place. But are there any situations where someone would come to you and say, I want to file this lien? Like, are there situations where you might kind of say like, well, let's hold off there. Here's how a situation could backfire. Here's some reasons why you might not be able to file this lien. Here's some reasons why a lien might be expose you to more risk. Anything to think about like that?
Yeah, so I think there are kind of a few considerations. I mean, I mentioned one a minute ago where if it's debatable whether the work is lienable, you might sink legal costs and aggravation into filing a lien and having the lien challenged. And you may have a client that says, well, I supplied the hand soap in the bathroom on the construction site and I want you to file a lien. And you say, well, I'm not really sure it's debatable. Let's file the lien. Well, you may get a petition for discharge.
Right.
Then you may have to go to court and file, if you're the liener's attorney, you may have to go to court and file an opposition. And ultimately the court is probably going to vacate the lien. So now you've spent your client's money filing and attempting to defend a lien that eventually was vacated by a court.
Right. Whereas you could have just filed a civil action and saved all that time and energy.
I supplied $10,000 worth of hand soap and the general contractor promised to pay and never did. It's not as if not having a lien means you're out of luck, right?
Right.
So that's sort of the first one, is that you may think twice about going down that road if there are doubts about the validity of the lien. I guess similarly, if you don't have great backup for the lien, right? If you don't have, really clear and timely prepared requisitions and invoices and proof of the work and that the work was done as required under the contract, you might wind up in a similar place. And what I mean by that is you might file a lien and go down the road of trying to enforce it only to have the lien challenged. Something I didn't mention was sometimes you might get hit with what's called a request for a verified statement of lien, which again is a sort of a short circuit to try and challenge a lien where the party filing a lien has to kind of come up and basically produce all the evidence supporting a lien prior to foreclosure. So similarly, if you have a lien where you might have a client that has some pie in the sky number they think they're owed, but it's really just, it all resides in their head and there isn't a great documentary trail supporting the lien, you might also think twice. You might just want to go the normal breach of contract, normal civil litigation route. Couple other things I guess to mention are, if you do overstate a lien, you're usually not going to get into trouble. If the law allows room for reasonable doubt, and you frequently see this where maybe it's a contract for a certain amount and there are some change orders that are in dispute, meaning work that the contractor believes is outside the scope of the contract and therefore warrants additional payment. And the owner says, no, you have a scope of work for X amount of money. I told you to do this thing. It's within your scope. I'm not paying you a dime more. The lienor may decide to include those disputed amounts in the lien, and generally that's okay if it's later determined by a court that those change orders were not valid. The lienor is not going to get into trouble. But I raise this because if you intentionally inflate the value of a lien, you can get into trouble. Totally. If you go to court to foreclose a lien and the upstream party, whether it's the contractor or the owner, really believes you've intentionally and willfully inflated the value of the lien, they're almost certainly going to file a counterclaim for willful exaggeration of mechanics lien, and there are certain penalties for that. So that's another thing to be aware of. I think the last thing is not really in the nature of a pitfall, but something that can catch people off guard. I think a little while ago you asked, well, what if you want to file a lien and kind of not really do much, right? Very common. Again, with smaller liens, I've got a $20,000 or $30,000 lien. It's going to cost that much in legal fees just to get into court. Let me kind of file this lien and like chill and see what happens. Because all parties with liens on the property or other security interests on the property need to be consolidated in a foreclosure action, what might happen is you have a client that filed a lien and kind of forgot about it. They may find that they have been named as a party to a foreclosure action brought by somebody else. Yep. Right? So a client picks up, you answer the phone and the client says, I don't really know what this is. Am I getting sued? It says I'm a defendant. I don't know who this party is. I think it's another subcontractor. I got a complaint in the mess. Summons and complaint was served on me. What do I do? And what that is somebody else, probably with a bigger lien or somebody that's more eager to try to foreclose and get paid, has started an action. They did a foreclosure action. They did a title report and they said, oh, there are 3 other liens on the property. Let me go bring those other lien holders into the case. So basically, you may have filed your lien, forgotten about it. You kind of just want to sit back and relax. Now you're being brought into the case somewhat against your will, and you've got a decision to make. You kind of need to go and hire an attorney. There's probably not going to be a whole lot of heavy lifting legal work to do, but somebody's got to go file a notice of appearance in the action and file some papers to actually indicate an intention to assert your lien. Because if you don't have to, right? You get served as a co-lienor in the case. You can kind of just say, all right, whatever. I don't really feel like dealing with it. But if you want to maintain your lien rights and not be deemed to waive your lien rights, you've got to appear in the case, even if you're not the one that started it.
Sure. All right. Well, we said we were going to talk for 5 to 10 minutes. I think we're on minute 25 right now. So I think this is
it's an issue that's really exciting to me. I may be one of the only people in the world that finds mechanics riveting, but hopefully people will start seeing things my way after they watch this.
I think it's certainly a helpful jumping off point for anyone who's thinking about these issues. And obviously, if you have a mechanics lien issue, please feel free to reach out to Brad, reach out to our firm. We'd be happy to chat and consult. And any further questions, just reach out. But Brad, thanks for the time. And we'll call it a day here.
All right. See you later.